The U.S. Supreme Court is once again being pulled directly into the post-Bruen gun rights fight, and this time the issue sounds simple on the surface, but could have massive nationwide consequences. It's being called the vampire rule, and depending on how the court rules, it could determine whether millions of lawful concealed carriers can legally carry in ordinary places like stores, restaurants, and hotels, or whether carry is effectively banned almost everywhere by default. Here's what's going on. After the Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruen, states were told they could not treat the Second Amendment as a second-class right. Discretionary carry permits, subjective standards, and vague restrictions were out. But several states didn't respond by loosening restrictions. Instead, they rewrote the rules. Hawaii is one of them. Under Hawaii's law, carrying a firearm on private property that is open to the public, like a grocery store, gas station, or shopping mall, is illegal unless the property owner gives explicit permission to carry. In other words, unless the owner posts a sign saying guns are allowed, carry is automatically prohibited. Gun rights advocates quickly gave this approach a nickname, the vampire rule. Like a vampire that can't enter a home unless invited in, a concealed carrier can't enter a business unless the owner affirmatively says yes. The legal challenge now before the Supreme Court argues that this flips the Second Amendment completely upside down. Instead of carry being lawful unless prohibited, the state turns carry into something that is banned everywhere unless specifically allowed, without individualized findings, without historical analogs, and without evidence that these places were traditionally off-limits. That's the core constitutional question. Does a state have the power to declare nearly all private property off-limits to firearms by default, simply because it's privately owned but open to the public? Supporters of Hawaii's law argue that property rights justify the restriction. They claim that because private owners have the right to control their property, the state can step in and create a default rule that protects those owners unless they opt out. Opponents respond that this argument doesn't hold up under constitutional scrutiny. Historically, private businesses open to the public were not treated as blanket gun-free zones. There is little to no historical tradition of governments banning arms in all commercial establishments unless invited, and that matters a lot under Bruen. Bruen established that modern gun regulations must be consistent with the nation's historical tradition of firearm regulation. Not policy preferences, not public safety arguments alone, history. That's why this case matters far beyond Hawaii. If the Supreme Court allows this kind of default ban to stand, states could effectively recreate no-carry regimes without ever saying the words. A state wouldn't need to ban concealed carry outright. It could simply declare that carry is prohibited in all private spaces open to the public unless the owner opts in. That would include stores, restaurants, movie theaters, office buildings, apartment common areas, and more. In practice, lawful carry would shrink to sidewalks and your own home. That's exactly what challengers argue violates the Second Amendment. During oral arguments, the justices focused heavily on the scope of the restriction. Several question whether the law leaves any meaningful room for the right to bear arms at all. Others pressed Hawaii's attorneys on whether there is any historical evidence supporting such a sweeping default prohibition. The tension was clear. If the court allows this rule, it risks creating a roadmap for states hostile to gun rights to sidestep Bruen without technically defying it. On the other hand, if the court strikes the law down, it would send a strong message that Bruen has teeth and that states can't use creative drafting to nullify constitutional rights. There's also a broader issue at play here: selective constitutional treatment. We don't apply default bans to other rights this way. Imagine a law saying speech is prohibited on private property open to the public unless the owner posts a sign allowing it, or that religious expression is banned in public-facing businesses unless expressly invited. Those laws would never survive. Yet that's essentially what's being done with the Second Amendment. Another key issue is enforcement and confusion. Under Hawaii's rule, a lawful carrier has to constantly guess which businesses allow carry and which do not. There's no universal signage requirement, no clear standard, No way to know in advance without risking arrest. That uncertainty itself can chill the exercise of a constitutional right. The Supreme Court has repeatedly held that constitutional rights cannot depend on guesswork or fear of punishment. That principle could weigh heavily in the final decision. So what happens next? The court's ruling, expected later this term, could fall into a few categories. The court could strike the law down entirely, ruling that default bans on carry in private public-facing property are unconstitutional under Bruen. It could uphold the law, giving states broad authority to regulate carry through property-based defaults. Or it could issue a narrower ruling, limiting how far states can go while leaving some version of the rule intact. But make no mistake, whatever the outcome, this case will shape gun carry law nationwide. Several other states have already adopted similar rules, and many more are watching closely. If Hawaii wins, expect rapid expansion of these laws. If Hawaii loses, expect a wave of challenges and rollbacks. This case is about far more than signage on doors. It's about whether the right to bear arms exists in real life or only on paper. And once again, the Supreme Court is being asked to decide whether the Second Amendment means what it says. When the decision comes down, it won't just affect Hawaii. It will redefine where, when, and whether Americans can actually exercise their right to carry. And that's why this case matters.